afternoon, everyone. Welcome to our thought leader encounter with Nyasha Karimakwenda. And also welcome to one of our hub events. I really don't think I need to introduce the hub some more. But this sort of series of our hub is really aimed at sort of bringing thought leader encounters, or thought leaders, and Nyasha I think definitely qualifies as one, into contact with students and UCT staff members. I think you all know what the title of the seminar is, but just a little introduction to Nyasha. She's a feminist researcher and consultant on gender and women's rights. She's worked and conducted research in the US, in the UK, and Southern Africa. And her research focus is on contextualizing forms of gender violence against women in South Africa. And she's currently completing her PhD in public law. And she'll be talking about what her research has looked like so far, just sort of generally imparting wisdom onto us. So I'll hand it over to you. Thank you.
It's my first time using a microphone. Is it too loud?
No, it's perfect.
It's perfect.
Yes.
Speak louder? Okay, it sounds so loud to me. Okay, so good afternoon, everyone. I want to thank you for being here. I know you could have used your time in other ways, so I really appreciate you being here today to talk about this issue, which is really, really important. Fatima gave an introduction, thank you for that, and thank you to the CLS for being here, and thank you too for my colleagues from the London Accountability Centre for being here and supporting me. So I'm towards the end of my PhD journey, and I've been doing my PhD here in public law. And when I tell people that I've done my PhD on marital rape, a very common question I get is, why would you pick that subject? One of my cousins said, but that's impossible. The Bible says you have to submit to your husband. So how's marital rape even possible? But I still continue to claim that the reason why I need to do this research is because of those kinds of questions, of people who think that marital rape is not important or that it doesn't exist. And the subject came to me about a decade ago. I was doing my master's in the US, and I came across two judgments by Chief Justice Mohoen, who's now, the Chief Justice of the Crown Court. And at the time that he was being appointed, there was a big outcry from civil society, feminists especially, because they were very upset at his track record. He has some very problematic judgments on sexual violence. And two of the judgments that I came across were related to marital rape. And in those judgments, in determining the sentences for the husbands, the judge used the marital relationship as a way to diminish the husband's culpability. So in essence, the judge said, okay, because of this marital relationship, this prior intimacy, this makes the rape not as serious as it would have been otherwise. Now, living in my feminist bubble, I was completely shocked and horrified. And I said, okay, I'll park this issue and I'll come back to it. And I decided to come back to it this year, almost a decade later. So today I'm going to be talking to you about contemporary South Africa. And I'm going to talk to you about mechanisms that I've identified that continue to perpetuate the idea that rape in marriage doesn't exist. And what do I mean about that rape does not exist? This is where I bring in the idea of invisibility, and it goes to two meanings. It has two connotations. One connotation of invisibility that I use is that marital rape is considered to be a far less serious crime than stranger rape or gang rape or rape in other contexts. So it's considered to be a trivial matter, and this comes from a historical grounding that I will talk about. The other connotation of invisibility is the fact that marital rape is really a very hidden issue. It's not something that captures public imagination. It's not something that we see on the news. It's not something that's even prevalent in literature. And that was another thing that really compelled me to do this research. I was wondering, where are the debates on marital rape? So that's what I'll be talking about today, in the context of formal institutions, meaning law, policy, and academia, right? So before I continue, how is the volume? Is it fine? Even in the back, Nobindi? Okay, thank you. So, as Fatima mentioned, I identify as a feminist. That word can sometimes seem scary, but it's a word that I own. I don't believe in feminism with a capital F. I truly believe that anyone who claims feminism has the right to make it their own. So to define it for themselves, to make it real in their lives, and then the label really doesn't matter. Feminism is about interrupting and disturbing status quo, the status quo, dominant discourses. It's about unearthing women's voices. And as one of my mentors told me, it's about being subversive in everything that we do. So it's part of a struggle to make women's voices heard and to make their realities more understood and more apparent. And as a black woman, I also pay attention to how race intersects with gender, because race and gender and other forms of marginalization intersect to produce very different experiences for those who live on the periphery of society. So I like how there's a black feminist called Barbara Smith, and she said, black feminism is about looking at the simultaneity of oppressions. So that's what I try to do in my work. So before we get into the topic of marital rape, I also just want to acknowledge that this is a very, very emotive topic. It's a very painful topic, and what's going on with this?
You good?
It's fine. Okay. And I understand that it is highly triggering. Especially living in South Africa, many of us have experienced sexual violence. There are people close to us who have experienced sexual violence within our families, within our communities, and at the hands of strangers. So I do acknowledge that this is a very painful topic. If you do find that you are being impacted detrimentally, make sure that you look after yourself. You can take a break, talk to somebody, please get the help that you need, okay? And I'm sure at the CNS we'd be happy also to find resources if any references need to be made for care or counseling. Okay, so let me give a bit of history about how marital rape has been treated in South Africa. And then I will be delving into the subject of ukuthwala, and I will go into what ukuthwala means. So for those of you not familiar with it, don't worry, I will explain in full. But in short, it refers to customary practices of abduction for purposes of marriage. That's the simple and simplistic definition of it. But to go back into history, marital rape only became a crime in South Africa in 1993. Okay, so it's been a very, very short time. Before that, husbands could not be held liable for raping their wives. It literally was a crime that did not exist. So a husband could be prosecuted for assault, but he could never be prosecuted for rape. And that was called the marital rape exemption. So let me look at the different traditions that make up South Africa's law. We have vernacular law, and that's a term I've adopted from Cindy Somnisi Weeks. She uses the term vernacular law because the word customary is a very, very loaded term. It's very problematic based on our apartheid and colonial history. So I try to use the word vernacular or localized forms of law. Now, one can never, you can't paint the whole country with the same brush. So of course, different traditions have different ways of looking at marital rape. But what the general picture was, that for most of history, in our local cultures in South Africa, marital rape was not per se considered a crime. And what does that mean? It meant that upon marriage, it was assumed that a husband gained sexual access to his wife. That's what's referred to as ixorial rights. That means that he had the right to access his wife's body. And upon marriage, she lost the ability to say no. So that even though marital rape did take place, even though women were brutalized and raped, they couldn't go to a family tribunal or to a headman and necessarily say, my husband raped me. Maybe they could talk about general mistreatment and other things, but marital rape was not a discrete issue, okay? But in all vernacular systems, there were means of protecting women. So there was a balance. There were systems where women could protest. There were systems where women could run to their families for protection. But as colonialism and as apartheid became stronger and stronger, and many colonial systems became rigidified, many of these protective mechanisms began to fall away. And there were less creative ways for women to express their agency. But in essence, marital rape was not a crime. And perhaps at the end, I'd be interested to hear from some of you about your own experiences within the communities, within the places that you've grown up, about whether marital rape has been an issue and how it has been received. Okay, so those are in your localized systems. In common law, so South Africa has inherited its common law from two traditions. One is English law, and one is Roman Dutch law. So those form the basis of South African common law. And both of those traditions were highly, highly patriarchal. So under the English branch, we have a statement from 1736 by a man called Sir Matthew Hale. And he wrote in 1736 that marriage is a contract. And once you're married, and the wife says yes, she doesn't have the right thereafter to say no. So marriage was seen as an irrevocable contract. And that actually formed the basis of the marital rape exemption in most of England's colonies. And some still have that exemption today. So it was present in the US and again other Commonwealth nations. The Roman Dutch position was even more harmful because the exemption there was based on a wife's insubordinate position. So according to Roman Dutch law, women are naturally inferior. When a woman becomes married, she's basically under her husband's authority. So you can find texts going back to 1650 onwards which state this position. It was a very rigid position, sorry. So that is the basis of South African common law. So by the 20th century, what you have, if you look at jurisprudence on marital rape, you have courts defining marital rape as carnal connection by a man with a woman, in quotes, in brackets, sorry, not his wife, without her consent. So I'll just repeat that. Carnal connection with a woman, not his wife, without her consent. And that's how rape was defined up until 1993. So how did we come to criminalize marital rape? There were indications in the 1980s that things were going to change. In 1985, the South African Law Commission recommended that marital rape be criminalized, and there were also some courts which were beginning to push against the idea that wives were inferior to their husbands. But ultimately, by 1989, Parliament rejected the South African Law Commission's recommendation that marital rape be criminalized. And even when the Commission made that recommendation, that in itself was problematic. Now again, what feminism calls us to do is to look behind the surface. So at the time we might have thought, fantastic, they're saying we should criminalize marital rape. But the essence of their recommendation was still highly patriarchal and in effect was quite empty. So what the recommendation said was, we'll criminalize marital rape, but prosecutions can only proceed upon the permission of the Attorney General. So for any cases to move forward, all the cases in South Africa, the Attorney General has to approve. So that in effect rendered the undoing of the exemption empty. It rendered it meaningless. But this is to just say how prominent the cultural norms were, the socio-cultural and legal norms were that sustained the exemption, that it still held fast in 1985. So they put forward this recommendation, they sent it to Parliament. Parliament debated, all the houses, the three houses at the time looked at it, and ultimately they said, we're not going to criminalize marital rape. And what they did is that they further entrenched it by writing it into statute. So by 1989, marital rape was recognized by statute. So in a sense, the law took several steps back instead of going forward. And I just want to read you one of the statements by a parliamentarian, because at the time they were quite proud of themselves. They actually thought that they were doing something big. And both men and women actually voted in support of this. So the parliamentarian said, "It is simply unacceptable for one partner," he's talking about the husband, "to be subject to the highest penalty, even in cases in which no violence has taken place. If the other party unreasonably refuses sexual accessibility, and that party is left unpunished. This is the kind of inexplicable situation that arises when criminal procedure becomes involved with the most intimate things in the law of family." So bound up in that statement, you have several strands and several marital rape myths, and rape myths are bound up in that. One of that is that rape is not itself a violent crime, and that's something we see commonly in jurisprudence on rape. The other is that a wife refusing her husband sex is a punishable offense. And the other one, of course, is that family law does not deserve intervention. Family violence does not merit intervention by the state. And the other, of course, is that marital rape is just not a serious crime. Okay, so there were many things bound up in that parliamentarian statement. By 1993, marital rape is criminalized, and it was done by the Prevention of Family Violence Act, and it criminalized marital rape without qualification. And you might ask yourself, how did this happen when just 4 years before, Parliament staunchly supported the exemption? At the time, feminist commentators said that actually this act wasn't about protecting women. It was actually a last-ditch attempt by the apartheid government to get the vote from women, or to be seen to be doing something for women. Another problematic aspect, when I looked at the records, in the first iteration of the law actually kept the marital rape exemption. So this is a Prevention of Family Violence Act, and in the first draft, they kept the marital rape exemption. In the second draft, what they did was to include criminalization, but to again have that Attorney General oversight. And in the third draft, that's when they criminalized marital rape, and that's what was passed. Fortunately, with the advent of democracy, we had greater and greater feminist influence in the laws. So by 1998, we had the Domestic Violence Act, which was passed. Professor Rashida Manji was very involved in that process. And that act keeps the provision from the PVFA that criminalizes marital rape. So the Prevention of Family Violence Act doesn't exist anymore. The only provision that exists is the one criminalizing marital rape, and you can find it in the Domestic Violence Act. Then, the law began to progress more, and none of these laws are perfect. If you talk to the feminist experts who are involved, none of these laws are perfect, but they are better than what came before democracy, because now the state began to integrate women's expertise and women's voices from different sectors. We also have two other laws which signal the importance of marital rape, and those were passed in 2007. One of them is the Sexual Offences Act, also known as SORMA. And what that says is that a person cannot use the marital relationship as a defense to rape. So that's prohibited as a defense. Also, in the Minimum Sentences Act, which prescribes the sentences that justices should pass down for rape, that says that the judge cannot rely on a person's religion, it can't rely on their culture, and it cannot rely on a marital or other relationship. So these were all inputs by feminists to push back against the marital rape myths and rape myths that began to continue to resurface in jurisprudence on sexual violence. Okay, so that's the background. And before I go into talking about the invisibilizing factors, do you have any questions? Okay, are we all clear? Can you hear me?
Yes.
Is my pace okay? Okay, sometimes I tend to talk a bit fast. Okay. So you can tell me if I need to slow down. All right. So now the invisibilizing factors, and this is what the crux of my research is about. So I've demonstrated how for most of mankind's existence, husbands could not be guilty of raping their wives. It was a crime that didn't exist. So I was curious, especially reading those very disturbing decisions by Mogoeng. I was curious about how these myths continue to proliferate in the democratic era. And so I wanted to understand the mechanisms, I wanted to understand how they manifest, I wanted to understand their impact. Essentially, even though the marital rape exemption was done away with, how does it continue to stay alive in practice? And that's what my research looks at. So one of the areas that I have centralized in my research is the subject of ukuthwala. Before I continue, has anyone not heard of ukuthwala before they came to this talk? Is anyone completely unfamiliar? I'll still describe it, yeah, okay. So ukuthwala it's the isiZulu and isiXhosa word for abduction. To carry away. That's what it literally means. It means to carry, or to carry away. But what it refers to is a sort of amalgam of local practices where women are abducted for purposes of marriage. And this is a practice, it's a living customary practice, and it goes back centuries. We have records from the 1800s onwards talking to this practice and documenting this practice. But the term ukuthwala is also, it can be misleading because it makes something very complicated seem simple and uniform. And it also doesn't quite recognize the fact that it's practiced across South Africa, and each community has its own name of the practice. So I don't think that there's any grouping in South Africa that doesn't have some sort of abduction for purposes of marriage practice. Sometimes it's done coercively, so sometimes it's done with violence and rape. Sometimes it's done as a form of elopement. Sometimes it's done to make a marriage happen faster. So it actually has quite a positive function in some contexts because it allows people to get married without paying much. It allows people to get married faster. And it allows people to sort of subvert family authority. So by no means is it only a benevolent practice or only a bad practice, but there are very, very positive uses of it. My research speaks to the violent aspects of the practice. Okay, so again, it's a complicated term, but basically refers to irregular avenues to marriage. Okay, does that make sense? Okay. If there's anything not clear, you can always raise your hands and ask me along the way, although we will have question and answer at the end. All right. So I began researching ukuthwala in 2012, and I came to South Africa, I came to UCT, and I started researching because around 2009, a discourse grew about ukuthwala, and I call it the ukuthwala crusade, which makes it a lot more exciting. But the crusade came out in 2009, and it was in response to this very heightened media attention. So all of a sudden in the news, you had these reports about young girls being kidnapped, being raped by much older men, and this was taking place mostly in the Eastern Cape and mostly in KZN, but in the rural areas. And people were just absolutely horrified. And what the journalist said was that, okay, this practice, it had sort of died away, it's very obscure, but now all of a sudden it's come to the surface again. But the main argument of the ukuthwala crusade was that the way ukuthwala was being practiced, meaning with violence, with rape, with coercion, was inauthentic. So in response to the rise of this distorted practice, so they basically said this was men abusing custom. In response to this, there was an urgent push by different sectors of society. So you had government, local and national and provincial, you had scholars, you had civil society, all mobilizing around this issue. It became a really, really prevalent issue. So that was what the ukuthwala crusade was. And people said, we need to stop this practice, we need to return it to its benevolent form, and we need to rescue these young girls. I don't have a problem with any of that, because of course it was happening, and girls do need to be rescued. And some of these cases were happening with the family's sanction, and sometimes without. Sometimes very poor families were being taken advantage of, and sometimes it was orphan girls who were being abducted. So it really, really was and continues to be a very serious issue. My particular issue is that out of the ukuthwala crusade, there came a script, which I call the ukuthwala script. And what the ukuthwala script said is encapsulated in a decision called Jazile. Jazile was a decision handed down in 2014 by the Western Cape High Court, and it's the highest decision to ever look at the issue of ukuthwala in South Africa. And that involved a man called Vumeleni Jazile. He was from the Eastern Cape. He was 27, and he abducted a girl named Nolutho Yokiso. He abducted her, and she was 14 at the time. He abducted her with her family's sanction. So his family negotiated with her family. So he approached her uncle. She didn't have a father, but he approached her uncles, and lobola was paid, and then they abducted her. He then took her to Cape Town, to Philippi, where he worked, and he raped her after considering her his wife. And to him, she was his wife because the family had approved and lobola had been paid. At the first time that he raped her, because it happened on more than one occasion, he was living with his brother and his sister-in-law, and he called his brother into the room, and he said, please, can you hold her down? And as the brother held her down, he said to her, now you're a wife, you must have sex. And that's how she was raped the first time, and it happened again. She was able to escape, and she was able to get help, and the case was ultimately prosecuted. Jazile was sentenced to 22 years for kidnapping, trafficking, rape and assault, so 22 years, which is a very significant sentence, especially compared to other rape cases. And this was a very interesting case because what the judges did at the appeal level was to bring in experts. So they said, okay, this is an issue we don't really know much about. We need to call in some experts. So they called in several friends of the court. There were also other expert witnesses who came and testified because they wanted to determine what is the essence of this practice. Because Jazile tried to argue that because this was a practice that was authentic to his community, the court should take that into consideration, maybe see it as a form of as a kind of defense or explanation for why he'd done what he had done. So that's why the court wanted to understand this practice that it was quite unfamiliar with. On the basis of the inputs received by the experts, the court determined that the kind of ukuthwala that Jazile practiced was aberrant, meaning it was inauthentic. So the court said, well, this is inauthentic, this is not the way traditional ukuthwala is practiced, and whether it was traditional or not, they were still going to find against Jazile. So the outcome of the case is good, but we have to ask, what are the narratives, what are the assumptions the court is making about ukuthwala in its decision? And is it helping us to understand how sexual violence and marriage are interlinked, or is it further obscuring the issue? And my argument is that it's further obscuring the issue. What the court does is lay out the parameters of what it considers to be authentic ukuthwala. And the components, it said, were consent by both parties getting married, consent by both sets of families or parents, a mock abduction, so not a real abduction, a mock one, and then the woman being of a marriageable age, and the last one is that no sexual violence must take place as part of the process. That is what the court said is the correct form of ukuthwala. And that, in a sense, made the script a real thing. It was applied, the ukuthwala script was applied in Jazile. But Jazile did not act by himself. He didn't go and abduct Yakiso by himself. He did it with family sanction. So what kind of narrative is the court engaging in? Whose voices are being silenced in this process? And how is women's suffering also being eclipsed in this process? So I began to ask these questions because it didn't make sense to me that a practice could just come out of nowhere, that men would just all of a sudden start raping women and the families accept it and everything is fine in these communities. That doesn't make sense. And I said to myself, and others have written about this, there's slowly a burgeoning literature on this, that the mainstream discourse of ukuthwala is highly distorted in itself. So I identified that the ukuthwala script and narrative are guilty of something called culturalism. And culturalism basically refers to a way of demarcating the bounds of culture as fixed, as rigid, as inherent in certain groups of people. And culturalism is most often used in groups that are not white, in groups that are poor, in groups that are marginalized. It's a way of actually seeing people as culture, people as representing their culture, as culture being inherently embedded in them. And this is something you see often with black people, in the way black people are portrayed, that we are our culture. Like we're born with this, it's not something that can be removed. We must all get married this way, we all do this in this way. We're less thinking about what we do. Whereas for many Western civilizations, they are seen as being cultured, but not as embodying culture. So what the culturalism of ukuthwala does is to imagine a metaphorical fence around black people and to say that, okay, this is how ukuthwala is practiced. And there are no other ways that this is practiced. But this is obscuring the other voices who are claiming, but no, in our communities, violence is the norm. Violence is accepted, and this has happened for centuries. So again, my issue is not with the outcome of Jazile and other cases, because girls do need to be protected. My concern is with the assumptions and narratives that are becoming stronger and stronger as we turn a blind eye to how much violence is sanctioned within marriage. And recall that this is something that takes place across communities. It's not something that is exclusive to black communities. It has happened all over the world, and many countries today still have not criminalized marital rape. So I found it important in my research to go out and talk to communities. And I went to an organization called Masimanyane, based in the Eastern Cape. Their main office is in East London. And they started an ukuthwala project a few years ago, around the time of the crusade, because remember, many groups were mobilizing. And when they went to communities, they started to realize that, okay, we need to shift the way we're looking at this issue. So they went to the communities, they asked the older women, can we have permission? Can we come in and help your girls? Can we provide counseling and education? And the older women said, that's good, it's all well, we welcome you, but please start with us first. And they said, start with us because we are carrying the scars of this practice. This happened to us as girls. Nobody spoke about it, we didn't get help, we are traumatized, and we also need to have a cathartic experience. And in the process of my fieldwork, I also spoke to 2 survivors of the violent form of ukuthwala. At the time I spoke to them, they were now they're in their early 60s. So they were twala'd, one was 14 and one was 16. And they too spoke about the fact that rape was an accepted part of them being abducted. It was arranged with their families, their husbands came and got them, they had no idea what was happening, their families let them go, and they were raped as part of the process. And in one of the women's cases, she explained it to me. She said that the way it happened to her, the way it happened in her community is that you're brought to the homestead, you're taken to a room. At the time you're abducted, you don't know who your husband is. So you have a bunch of men abducting you. They put you in a room, and when a man comes in, that's when you know who your husband is. Because all along, he hasn't identified himself during the abduction process. And then he's expected to take your virginity. And the family will stand outside the room to make sure and to listen. And then afterwards, he had to take a blood-stained cloth to show his family that she had indeed been penetrated. So that's how it happened. And in addition, rape also it had a practical function, if I may put it crudely, because it was very common for girls to run away, and so he was extra brutal in the process so that she couldn't walk. So she wasn't able to walk for a week. So she explained. So this was very enriching to hear her experiences and to understand the function that rape performed in her life and in the start of her marriage. Both of the women continue to have very abusive marriages, and both of them still carry trauma today. One of them suffers from high blood pressure. Her kids don't want to get married because of how abusive and traumatic her relationship has been. When some of these women went to testify before some commissioners from a Chapter 9 institution, they told the people on the panel, this is how ukuthwala was practiced in our communities. This is our ukuthwala. Rape is a part of the process. One of the commissioners, a woman, said, sorry, but that's not ukuthwala. That's not our ukuthwala. Call what happened to you something else, but that's not our ukuthwala. Now that is the ultimate form of silencing. When you have a woman who is allowing herself to be vulnerable before a government panel, and she's being told that what she went through was not what is called in her community and not what is practiced in her community. So you see how the script, which people who know nothing about ukuthwala, or who think they know, or who have listened to elites, or have read a text from 1975, who think they know about ukuthwala, they are failing to listen to women and completely invisibilizing them and silencing them. That is my problem with the ukuthwala script. It eclipses women's narratives, especially older women. Ukuthwala is not, yes, it's framed as a child marriage issue, it's framed as a forced child marriage issue, it's framed as a trafficking issue, because that's how it's prosecuted. But at essence, it is actually a marriage and rape issue. It exists along the spectrum and continuum of marital rape. What happens at the start of a marriage also continues into the marriage. And the sanctioning of sexual violence comes because of the institution of marriage. The institution of marriage, in practice, transforms women into ownable and rapeable beings. And that has been the case since time immemorial, and despite the law's change, it continues to happen. So that's the culturalist element of ukuthwala. Before I continue and conclude, I just want to talk about some of the jurisprudence that I've come across for so-called ordinary marital rape cases, so cases outside of the context of ukuthwala. The most disturbing case I came across, and I looked at 6 decisions from the High Court level up. The most disturbing case was a case called Mbamvu. And this was a Supreme Court of Appeal case, and it also smacks of culturalism. It also perpetuates marital rape myths. It involved a customary law husband and wife. In the wife's mind, they were no longer married. The husband was very abusive, and she got permission from her family to leave the marriage. In the husband's eyes, they were still married, and this was clearly a very violent relationship because the wife went to the court to get a protection order. Coming from the court, the husband abducted her, and he raped her. She managed to escape. He tracked her down again at her family's home. He abducted her at knife point and he raped her again. Over the course of the 2 kidnappings, he raped her 8 times. So the lower court imposed a sentence, but it was a very flimsy sentence, like I think less than 10 years. Because normally multiple rapes should attract a life sentence. That's what the minimum sentencing laws prescribe. We hardly ever see that in case law, but it should definitely not have been less than 10 years. What the court did was to rely on a very, I'd say almost racist. It's quite racist. The judges themselves were black, but that doesn't mean that they're not perpetuating racist tropes of culturalism, tropes of rural, almost rural savagery. So what the court did was to say, okay, this husband, he's a rural man, he grew up in the Eastern Cape, he doesn't really know better. The wife also grew up with him, she should, kind of understand what this is about. And they found that the husband shouldn't really be given a high sentence because what they were saying is that a different standard should be applied to black people and to rural people. But this is to the benefit of the husband and to the detriment of the wife. I'm going to read you some of the language from that judgment because it's quite shocking. And one has to ask too how such language can exist in the present, especially at the Supreme Court of Appeal. So in support of the husband, the court said, it is clear from his evidence, meaning the husband, that at the time of the incidents, the accused honestly believed that he had some right to conjugal benefits. His actions, though totally unacceptable in law, might well be explicable given his background. He grew up and lived in a world of his own, of tradition and black medicine, which was not completely strange to the complainant. They grew up together and come from the same area. And the court continues. His actions were shaped and molded by the norms, beliefs, and customary practices by which he lived his life. Though the rapes were accompanied by some acts or threats of violence, it does not appear that the prime objective was to do the complainant harm. I'm sorry, guys. He wanted the complainant back home as his wife, in one piece. The threats he made were empty, albeit designed to frighten her. So that's the conclusion the court came to. And in presenting rural black people as uncivilized, as possessing a proclivity to violence, what the court does is to explain away the husband's behavior as though he doesn't have the ability to distinguish between right and wrong. What it does is to signal to women, and especially black rural women, that they actually deserve less and that they should expect less because they grow up in the rural areas and there's a different standards for people from the rural areas. And mind you, throughout the trial, the husband showed no remorse at all. No remorse whatsoever. And at the time of the second kidnapping, he knew the police were after him. So this was not an unthinking man. He didn't do this by accident. But ultimately, the court, even though they approved the sentence and the conviction, their language shows that they really, really do not think that this is an important issue. Another thing they did was to say that the wife's injuries were trivial, very minimal. they found, okay, no real psychological issues, no real psychological trauma. So what we find from Bambo is not only is the marital rape issue obscured, but black women in the process are dehumanized. Because apparently this woman doesn't feel. And apparently it's okay for her body to be violated again and again. So in conclusion, I hope that what you've gotten from this talk is just a greater appreciation of how serious the issue of marital rape is, and how even in this democratic era, in this human rights era, the era where we have Women's Month, we have 16 days of violence against women, there are still many aspects of sexual violence and gender-based violence in this country that we are missing. We still don't yet know as much as we should know. We still don't understand as much as we should understand. And the things that we need to understand the most are often the things that may be the hardest to accept. You can tell with the ukuthwala crusade that there's almost a fear to acknowledge that this is taking place. That's why the script paints the violent ukuthwala as anomalous, as unusual. I'm really sorry about this microphone.
Step back.
Step back?
Yeah.
Okay. Oh, thank you. So, it's important that we continue to listen to women and to understand that marital rape is actually prevalent. When I went to Masimanyane and I spoke to the counselors and I spoke to women, they said that there's a high correlation between forms of physical violence, economic violence, psychological violence, and rape. It's just that marital rape takes much longer to come to the surface. Much, much longer, so it requires patience and empathy and understanding, and not assuming that rape is not taking place. Thank you for listening.
Okay, so we luckily have plenty of time for questions. I see Anine's hand and Grace's hand. Annika, was yours up too? Yes. Anine, Grace, and Annika. Anyone else want to be in the first? Okay. Anine, take it away.
So, a comment and a question. Firstly, that was an utterly brilliant presentation. I feel like you took me through your very nuanced reasoning step by step on a subject I knew nothing about. It was efficient. It was honestly, like, you've settled on the perfect way, I think, to get across these ideas. Like, it was just great. Thank you. So, the question is, actually, I'm going to sneak in two questions.
Okay.
So firstly, on a sort of more emotional level, how on earth have you managed to survive doing this research? I mean, listening to it for 45 minutes and I'm like a puddle. Like, how have you managed that? So, and then on another level, so I know with the whole Me Too movement lately, some people have been saying the next sphere for that is going to be marital rape, or at least rape and sexual violence within relationships, and that's somewhere we haven't gone yet in this conversation. I wonder if you have any thoughts on whether this can be extended there, whether this international movement can be productive in this context as well.
Do you want to answer one at a time or take several?
So we had Grace next and then Annika. Up to you. What? Grace?
I wanted to ask about the script that you mentioned, the script from that one judgment.
Yes.
So as you were explaining it, and I haven't read the judgment, it sounds a little bit like the reason the court called all these experts in Amakai was to determine the extent of the practice and its the validity kind of judgment. And it sounds to me like when they came up with the script of these tests for at what point does this practice become unacceptable, they were trying to ascertain how we allow a cultural practice to exist without it becoming really problematic and violent. And almost, and I say this without having read it and without knowing the intimate details, almost sounds well-meaning in a how do we include cultural practices, but then put a stop to, or put a kind of stopgap where it starts to go down a slippery slope. But my question really is, so your problem with the script, the issue that you've taken with it, is it because you think that one shouldn't exist, so the court shouldn't be almost trying to codify like marks of where it ends, or that you think it should read differently or should look different. And I thought about it in context of the lady who then said from the Chapter 9 institution, who said this isn't what our ukuthwala looks like, it looks like something different. And how perhaps that kind of thinking might well be shaped by the fact that our ukuthwala has been defined in a very specific way, and yours is this thing we can't relate to. So yeah, so I think I'd just like to know, have you taken issue with the script because the script exists at all, or issue with the script because of what it says and how it's defined itself?
Okay.
I was just wondering if you could tell us a little bit more about your field work, because you mentioned like you did some work in Eastern Cape, and you also talked to an organization here in the Western Cape.
Yes.
But I was wondering, like, I mean, if there's been like any, I don't know, like fascinating insights, like when you did your focus group or interviews, if you experienced some different like challenges between those two regions, if there's like something that sort of like sparked your mind. Or
Okay. Oh my. I'm gonna turn this on. It's fine? Okay. Aline, thank you so much for the praise. Okay. Can you hear me still?
yes.
Was it off? It's on. I'm not used to microphones. So how did I survive? I'm very strict with my mental well-being. So, well, let me go back. When I first qualified as a lawyer, I was working in the US and I became an asylum lawyer. So I was working in prisons and I was working with people who were going to be deported from the United States. And my organizations worked to defend them from being deported. And what we did was to litigate cases under the Convention Against Torture. So we had to argue that some of our clients had been subjected to torture and shouldn't be sent back. And this means that I had to work very, very closely with survivors of torture. And I burned out in about 2 years. But what that taught me is that I had to, as passionate as I was about violence against women, and it's not a subject that I chose, I always say it chose me. I can't force myself to feel passionate about something else. It's something that's too close to home, that women in my family have gone through, and many, many loved ones have gone through. So what I had to do was to remain passionate, but also create some emotional distance, to remain empathetic, but to remember to look after my body and my spirit. So throughout all of this, what I would do is, talking to other people helped. So people like Ani, who also does work on sexual violence, Ruth, talking to my fellow PhD students who work with sexual violence helped. Dean Kelly also have a lot of experience. Rashida Mandri is also one of my mentors. And just talking to different people helped. Like to have a community of women and a community of feminists, that helped. But also I just do silly things when I go home. I watch soapies and beauty videos on YouTube. And I'm a foodie, so I make sure I'm eating really good food and I'm going out and reading fiction. But I won't say you get used to it, because sometimes I still read these things and I do cry still. But you learn to contain it a bit more. Yeah. And then as for the Me Too campaign, I wish I followed social media. So I know about the Me Too, I know that, but I didn't know that people were anticipating that it might go towards the marital violence route. I would actually say that unless the woman is divorced from her husband, I don't know if the Me Too campaign will do much. Only because rape in marriage is a completely different phenomenon. It is the hardest form of sexual violence to come to the surface. And that's because one risks further abuse, one risks ostracization by the family and the community. And another issue is that many women don't actually realize that they're being sexually abused. As women are conditioned, they go into marriage, and I heard this a lot in Eastern Cape, that women go in expecting that marriage is supposed to be like this. They're taught to persevere. So, and I'll talk a bit more about my field work, but yeah, it's hard. It's hard because it starts with the woman herself. And defining rape in marriage as rape is an ongoing process. It's a tumultuous process, it's a painful process, and it takes a lot of time and energy. But what it may do is signal to women. They may start to think and look at their experiences a bit differently. So it could be good in that context, but in terms of women revealing their experiences over social media, I hesitate about that too, because that could lead to further victimization. So Grace, the script. I have problems both with the fact that it exists and the content. So for customary or vernacular practices, they should actually never have a script, because the whole point is that they change and they evolve and there's contestation. So I work at LARC, and one of the things LARC does a lot is to question the way in which customary law was made this rigid concept, often to the detriment of marginalized people in the communities. So there shouldn't be a script for something that is supposed to be organic. And then I have a problem with the substance, because it's not an inclusive script. It says that this is the way ukuthwala is practiced, and it excludes all other manifestations of the practice. And what you find is that a lot of the experts who come and testify, they're testifying on the base of customary law texts. And those texts sometimes were done decades ago, they were done by outsiders, or they were done in particular communities. So they're only catching a slice, a segment of what's really going on in communities. So does that answer your question? So what the court did was laudable. I do admit that. Of course, and even if it found the custom authentic, it would have still found that Jazile couldn't use it as a defense, as it should. I think part of the problem is that courts are still grappling with how to look at living practices. And perhaps there was the fear too that if they acknowledged that this was an authentic version of the practice, then people might take that to mean that the practice is okay. So the court probably, like the law, with the law the parameters have to be very strict and delineated, but then you lose out a lot of nuance. You lose a lot of the nuance. So the law is not always the best mechanism or venue or vehicle for expressing the intricacies of intimate partner violence. And then, fieldwork. Yes, so I did my fieldwork last year, and I decided to focus on the Western Cape and the Eastern Cape because of the established relationships that my mentors had. So my supervisor, Dee Smythe, she put me in charge of Mosaic, and she'd also done work with Masimanyane. And Rashida has a very long-lasting relationship with Masimanyane. So I said, okay, I'm going to go where I really have these connections, because otherwise if I go in as a stranger, that would not be conducive to research. So after I got my ethics approval, went in, and I focused on talking to counselors. I made that decision because I wanted to get a sense of patterns, broad patterns, with women who've been working directly with women for many, many years, to understand how marital rape comes to the fore. And at first it was actually difficult, because one of the counselors said to me, but why do you keep going on about this marital rape issue? Some said they didn't see the cases a lot, some said, well, marital rape is just like intimate partner violence. And so I began to see that I had to understand why it was that these cases were not coming up, and why it was that some of the counselors didn't really see the importance of marital rape. But as I went on and on, the topic, I don't know whether because of my understanding or maybe just the people I happened to interview, the topic began to come up more and more. And I began to understand through the eyes of these counselors how prevalent the violence is and how horrific some of the cases are. It was a prominent, I must say, a difference between Eastern Cape and Western Cape is that when I went to Eastern Cape, the women were very open about talking about marital rape, and they spoke about it a lot, and they had a lot of experience. In fact, when Masimanyane goes to the field to do workshops, they bring up the subject of marital rape, and they tell women, if you don't want it, if you say no and your husband forces you, it's rape. And they said often the women will say, but this is the first time they've heard this, they don't understand. Because one of the things you'll hear a lot amongst isiXhosa-speaking communities is that to be a good wife is to persevere. So the women are taught you must persevere. The longer you stay in it, the more you bear, the more you suffer, the better a wife you are. So there's a lot of undoing, mental undoing, that has to take place. But yeah, and then talking to the survivors. I didn't prioritize talking to survivors. One, because it's a process of seeing marital rape as rape. Sometimes it takes women years to feel autonomous, to feel empowered. And I was also afraid of further re-traumatization. But the women I spoke to were clients of Masimanyanes, and the counselors were with us when we were speaking. So they felt safe and, you know, they were able to talk, but it was very, very painful. It was very painful, especially to see the older woman who was crying. And some of the cases, they completely changed my mindset. One of the cases I remember the most was, I went to see a staff member from Mosaic who works at one of the Ukuthwala care centers. And she had just come off her weekend shift. And she was shaken. And she said, there's a woman who came in this week, she's in her 50s. And she was filthy, she was in pain, she could barely walk. And she said that for the past few years, each weekend when her husband was getting drunk, he was raping her with a broom. And she was completely broken. And that case stayed with me, and it stayed with the counselor. But it changed that woman's life, because the counselor said probably if she had continued, the amount of damage that was being done to her body, she probably would have died. So the police were able to arrest the husband, and I still need to follow up, I need to check in with her, but yeah, they were able to arrest the husband in that case. So yeah, so there was a lot of pain, but it also showed me the importance of speaking to women and going out into communities and being patient with finding out about things like intimate partner violence and marital rape. Okay.
And the importance of fieldwork, yes.
Yes, fieldwork.
The whole story is just...
Yeah, there's no way one can...
I see Rashida's hand. Are there any... okay, one. I'm afraid I don't know her name. Gloria, and then? Rose, okay.
Thanks so much, Nyasha, having read some of the drafts. The question I have on Jazile is, how do they insert trafficking into it? Because, you know, trafficking has elements which I can't see. This was one accused, one victim in this. So why trafficking? And is it because, I mean, if they had looked at marital rape, that's already criminalized. We don't need a specific crime on ukuthwala, unless someone does some thumb sucking and things, and so you need it. Why trafficking?
Thank you, Nyasha. This is amazing. I have a question on, I'm not sure if your research provides recommendations or suggestions or like ways forward. The thing that kind of jumped out at me was this issue of the ascertainment of customary vernacular practices and the problems that the common law and this requirement for certainty has when, you know, trying to figure out which practices are authentic or valid, etc. And how you think we can get around that? How do we teach something that's so malleable and fluid, let alone, you know, like, yeah, how do we teach it?
Okay.
Rose?
Thank you.
You spoke earlier about customary law and that it should be organic.
Yes.
Can you talk a little bit louder, Rose?
Okay, sorry.
Thank you.
I said you spoke earlier about customary law and that it should be organic. So my question is, how do we grapple with upholding the rule of law and the ever-changing nature or form of customary law? Because if laws are codified, it should be found or substantiated in precedent. But if we can't set precedent with customary law, because as you said, it's ever-changing, how do we maintain that balance?
Oh, those are
Great
difficult
questions.
Nobody teaches customary. But I'm gonna try. Shall I answer those three questions? Okay. So, Rashida, I have to revisit the case, but I think they used the trafficking angle because of when he had transported her from Eastern Cape to Cape Town, and I think they said there was a specific purpose, like they sort of looked at it as an exploitative transportation and purpose. So I think that's where they got the trafficking from. And another thing is that the case, it wasn't really framed as a marital rape issue, it was framed as a rape issue. And again, that was the thing, that sort of discourse on the rape and the marriage was missing. And in fact, the court found that they weren't married. It didn't recognize the marriage. So it rejected that. So I think that's why they also were looking at these other things like abduction, kidnapping and trafficking. But I do need to revisit that to understand why. And it's interesting that...
Underage, wasn't she?
Huh?
She was underage.
She was 14.
So they couldn't recognize the marriage either way.
Yeah, that's true.
They had statutory rights already.
That's true. Yeah, they did have that. And it's interesting that you bring up legislation because you're probably familiar with the fact that the South African Law Reform Commission, they had a report on ukuthwala that was released in 2016, and in that report they put forward a bill, a draft bill, which is meant to address ukuthwala. Some scholars who have worked on this, like Leon Mambene and Helen Cruz, have made the argument that the law is not going to solve anything really. But why the Commission felt that this law was needed is that when you look at empirical evidence about how ukuthwala cases are being looked at, in Eastern Cape, most times the prosecutors are refusing to prosecute. And they're refusing to prosecute because people come and say, okay, I was put through ukuthwala, and so the prosecutors are not really sure how to look at this ukuthwala thing, because it's hard for women to come and say, I was raped, I was kidnapped. So they come using the local name, and the prosecutors are not quite getting it. In addition, they prefer to send these things back to the community. They prefer to say, okay, go to your local traditional leader, go back to the family. So even though there's clear violence involved, even if they do know, they would rather that it's solved in customary systems. So that's also damaging. Another reason why these cases are not being prosecuted is that I was told of one case where the community actually stormed the courthouse and said, you are not going to proceed with this case. So the justice system is also wary about taking on this case. And what Jazile's community said to Mwambene and Cruz was that if that case had happened in Eastern Cape, it wouldn't have gotten as far as it did. And that's actually true. Because it was removed and because there isn't this localized understanding and sort of sanctioning of the practice, it was able to go through the full prosecution process. But it's true, changing, having a discrete crime, or calling it the forced child marriage bill, forced marriage bill, when we already have laws to cover that, I'm not sure if it will make a difference, especially at the local level. And then, Gloria, for the recommendations, and I think, Rose, it also kind of speaks to your question. How do we ascertain and create precedent when customary practices continue to evolve? I forget where I read this, but it might have been in Sindiso's work. But Sindiso Misi Weeks, who does a lot of work on vernacular systems of law, she says, or scholars have said that you only really need to determine the content of something when a conflict arises. For the people living in those communities, you live it, you breathe it, you know it, and you figure it out through the systems that's already in place. So it really shows the disjuncture between Western systems of law and local systems of law, because Western systems of law lean towards positivism, of wanting there to be rules, which is why the court said, this is what ukuthwala is, you must do steps A, B, C, D, and E. But that's completely contrary to how things are. So I don't know. I mean, having expert witnesses helps, but the expert witness can also never really speak to every iteration of the practice. All they can do is talk about the contestation and fluidity. And where experts also do help is where they want to help customary law move in a more progressive direction. So this has been the case, especially in customary law cases involving patriarchal practices. But I must say, it's also something I'm grappling with, and that the courts are grappling with, and they haven't yet gotten it right. Like, how do you take something that, the essence of it is that it does change, and that it's determined at the local level. Once you put it in a judgment, it takes away the fluidity of the practice.
Any more questions? Any?
Well, I would like to thank Nyasha very much, not only for her wonderful work, for her focus on
this issue on her general thoughtfulness as one of the other strong feminists in my circle, but mostly for allowing me to strong-arm her at the Women's March to come and do the talk today. Because I think your work is so impressive, Nyasha, and so thoughtful and so important that we really are very privileged to have you here today. And so thank you very much from CLS's side for all that you do in the CLS space, but especially for this presentation. And to all of you, who many of whom are CLS regulars, it's great to see you at another one of our events. As always, we are open to suggestions of people that you would like to hear from, topics you'd like us to discuss. So please do get in touch with myself, Fatima, Nalundi, at any time over email. But thank you for coming, and we hope to see you next time.